Hello, everyone. My name is Yael Shacher. I'm the Senior U.S. Advocate at Refugees International. Welcome to the fifth in our Voices from the Border series, a series of events to humanize, inform, and deepen policy discussions related to migration and protection along the U.S. southern border. Today's topic is detention and the need for humane alternatives. Until 2016, I was a historian focused on US immigration and refugee policy before 1980, so I actually didn't think that much about detention. Detention, in fact, has grown up with our contemporary asylum system. It first expanded and then was privatized to deal with asylum seekers from Haiti. And then after 1996, after 1996, to those subject to expedited removal or subject to deportation on greatly expanded grounds. I was shocked when in 2017, I visited the Carnes Detention Center in Texas, which housed women and children seeking asylum. It was a prison, and these families had done nothing wrong. They had just asked for asylum at the US southern border. In 2019, I visited a detention center in Laredo run by the GEO Group, one of the biggest detention companies in the world. And I visited several times to follow the case of a Guinean, an asylum seeker from Guinea, who was detained there for almost a year. He beat the odds. He had an attorney, and he actually managed to convince an immigration judge through a television that he deserved, through a television screen, that he deserved asylum, even though this judge did not have a very, did not usually grant people asylum because he had a very good case. So he beat the odds, but we kept him locked up for a year in fighting his case under pretty terrible conditions in that prison. ICE could have paroled him, but refused. Once you visit a detention center and see for yourself what's going on, you can't but search for a better way. Unfortunately, DHS does its best not to let you see what's going on. CBP detention, in other words, detention at the border when people cross, is only supposed to last for 72 hours, but especially under some of the Trump administration's special programs for asylum seekers that have been in place since 2017, that detention actually lasts much longer, and conditions are primitive and off limits to attorneys and human rights groups. Once an asylum seeker is a transfer or an immigrant is transferred to ICE custody, they're frequently transferred to remote facilities, far from counsel, far from family, far from the media. During the pandemic that we are in right now, ICE transfers has actually spread disease to different detention centers. Instead of releasing people, what ICE has done is, especially in jurisdictions where they've been told that they need to release people, they sort of transfer people elsewhere. And then rush deportations rather than releasing people in a safe way. A particular egregious situation is actually underway right now, in fact, where there are children detained in ICE's Berks facility and Dilley family detention centers, and they're about to be deported. Some of these children and families were placed in proceedings that did not really allow them to apply for asylum because of policies that have now been deemed illegal. Still, they really don't have any chance to appeal their decisions, and they actually are, although they've been in detention for a long time, now ICE is speeding their deportation. Overall, immigration detention capacity then has expanded tremendously since around 1980. The United States had 7,000 beds in 1995, 20,000 in 2000, the year 2000, 33,000 10 years later. Last year, we had 55,000. COVID-19 has shrunk the system significantly. And for many reasons that we'll hear about today, we should not build the system back up, but we should instead find alternatives. we also need to do is figure out a better and more humane way to receive people at the border, because right now the border is closed to asylum seekers. And the reason given for that mostly is that there's no way to sort of allow people to seek asylum, because then they would have to be held in crowded CBP custody. So if we had an alternative way of processing people, we might be able to actually allow that access to the border, which is required under our laws and international law. So I'm going to introduce each panelist right now, but then before each of them speaks, I'll ask them a question, and I hope you'll understand from the question that I ask why I've brought them here today, and how they can introduce alternative ways of handling things and opening up the border, and sort of dismantling our detention system as it exists. The first speaker will be Heidi Altman, Director of Policy at the National Immigrant Justice Center. Next, Katharina Obzer, Associate Director in Migrant Right and Justice at the Women's Refugee Commission, and an author of an important report on case management, which is one of the alternatives we'll be talking about today. Then Sylvester Owino, a former asylum seeker and an activist who spent time in immigration detention and is on the Freedom for Immigrants Leadership Council. Next, Christina Fijalho, the co-founder of Freedom for Immigrants, which is an organization that runs all kinds of alternative programs that she'll be discussing today. Then we'll speak to some Canadian counterparts. Jenny Jeans, who's a detention program coordinator at Action Refugees Montreal, and Francisco Rico Martinez, who co-directs the Toronto's FCJ Refugee Center, which provides a lot of services for immigrants and refugee claimants in Canada. So let me open up with a question for Heidi to get things going. Every time I mention or talk to people about detention, they raise one issue with me. And the fact that they were shocked to hear about the medical neglect at the ICE facility in Irwin, Georgia, which got a lot of attention recently, mostly about forced procedures there. Can you contextualize what happened there for us within a larger US immigration detention system?
Absolutely. Thank you, Yael. And since I'm the first speaker, I want to take the opportunity to thank you, Yael, and Refugees International for pulling this together, and to all of you who are listening for devoting an hour and a half of your time today to this issue. It's meaningful. My name is Heidi Altman. So the National Immigrant Justice Center, where I work, is a legal services and advocacy organization. We work to advance the human rights of all immigrant communities, and we're Chicago-based, but I'm speaking to you today from from my home, where I'm working remotely from our DC office. And, you know, to your question, Yael, I think you're right. That is very much on our minds. And for the past several years, the American public and the world has gotten some glimpses into the very grim and dangerous reality that is ICE detention. And I imagine that many of you have heard about the hysterectomies performed without consent on women detained in Georgia. And what I'm going to spend my time talking about today and ask us to do is to really wrestle with the sort of uncomfortable reality that the horror endured by those women in Georgia was not an outlier event. It was not an extreme example. What happened in Georgia was actually a reflection of the systemic racism, abuses, and impunity throughout the US immigration detention system that has been there for years. And so a way to start thinking about that is to look at the term immigration detention, which is really itself a misnomer. What we're really talking about, to provide some context of what this system is that we're thinking about today, it's a network of more than 200 private prisons and county jails that ICE uses under contract to jail individuals while they are going through their immigration adjudication process. And so that includes arriving asylum seekers. It also includes in the same system people arrested in the interior of the United States by Immigration and Customs Enforcement who are facing removal. And this massive carceral complex, as you already heard a little bit from Yael, is really a very relatively new way to approach migration processing for the United States. So the system as we know it today dates back to the 1980s, when, again, as Yael referenced, the US government turned to mass detention as a response to the flight of thousands of Haitian refugees who were escaping the Duvalier regime. And this policy was very clearly and intentionally designed to deter Haitians from seeking asylum in the United States. And refugee and asylum advocates resisted forcefully, but the system grew. And it grew, in fact, on a line graph that we've actually explicitly charted. And what you'll see is that that line graph overlaps entirely with two other line graphs. The growth of the mass incarceration of Black and Brown communities throughout the United States over the same time period, and the rise of the private prison company lobbying industry. And neither is a coincidence. So for many years now, reaching back more than a decade, asylum seekers who finally reach what they hope to be the end of a long journey at the US southern border have been met with a jail cell. First met by a Border Patrol agent. They'll be held in Customs and Border Protection custody for hours or days, often in freezing cold rooms referred to colloquially as the ice boxes, and then shuttled to one of, as I mentioned, these more than 200 county jails and private prisons throughout the country that contract with ICE. They will not have the right to an appointed attorney, even though they will be forced to defend themselves against a federal prosecutor in front of a judge. Most are jailed in remote parts of the country where accessing the evidence that they need for their cases, especially in the midst of a global pandemic, is a near impossibility. And there's no set release date for asylum seekers in detention. Their release could come in a month or a year or longer, depending on a variety of factors over which they have no control. The judge they're assigned, whether they're lucky enough to find a free lawyer, the whims of the ICE deportation officer assigned to their case. So imagine, behind bars, managing the triggers that come with recent fresh trauma, and never knowing exactly or even approximately when you will be free. I will always remember the first time I sat in an attorney-client visitation room across from an asylum seeker. It was a man fleeing political violence in West Africa, who wondered out loud to me how it could be that the country he saw as a beacon for so long threw him behind bars for seeking asylum. So the US immigration detention system is defined at this point by opacity and abuses. Transgender people subject to transphobic slurs and abuse by guards, well-documented thousands of cases of individuals with mental illness decompensating in solitary confinement, people served moldy food. And again, these events are not outliers, but tragically commonplace examples, not just for the past 4 years, but for decades. People in immigration jails today are contracting COVID on average more than 13 times the rate of the US population. People in immigration jails are dying at higher rates than they have for 15 years. And for the past 4 years, this administration has in fact deepened the crisis in immigration jails by throwing away any semblance of discretion over who it detains or for how long it detains them. So immigrants with particular vulnerabilities, including the elderly, pregnant women, and people with disabilities, has skyrocketed. And asylum seekers face a blanket policy of automatic detention that is, as I mentioned, nearly always prolonged. These abuses are compounded by impunity. And an important point here is that that impunity is in fact intentionally baked into the system. More than 70% of ICE detention facilities are owned or operated by private prison companies. So those companies, of course, are incentivized to cut corners when it comes to health or safety to make sure that their shareholders and their CEOs reap profits. And overlaying the entirety of the detention system is a confusing web of detention condition standards that are neither uniform nor legally binding. The DHS's own Inspector General, the Department of Homeland Security's own Inspector General, has looked at the system of contracts and inspections that governs ICE detention and found that it results in close to zero accountability for gross negligence or intentional harm. And we've known this to be true for years. This isn't news. Independent medical experts, for example, have repeatedly over years found that about half of all deaths in ICE custody are attributable to medical negligence. And yet at the same facilities where multiple deaths have occurred, egregious lapses in medical care persist. And so what does this bring us to? Well, at the National Immigrant Justice Center and many of our partner organizations, after many years of representing and meeting with and advocating for and alongside people who have been subjected to this system, we've come to realize it's not a system that can or should be fixed. It's a system that must be ended. And this is especially the case given that we know we can do better. That's what we're here to talk about today, and models exist to pave the way. As many of you know, and as Yael referenced, the situation on the US-Mexico border today is quite anomalous. Using the public health crisis as a shield, the administration has essentially closed the southern border to all asylum seekers against the advice of public health experts. And because of the border closure, very few, if any, asylum seekers are even able to access that first encounter with the Border Patrol agent. Very few are in detention. Most, hundreds of thousands, in fact, are expelled back to harm. We hope that the Biden administration is going to heed the advice of public health experts and open the border safely to asylum seekers. And when they do, it presents a truly remarkable opportunity for us as a country to rethink entirely the way we process asylum seekers. And we hope you will join with us today in working towards ensuring that that rethinking embraces a welcoming approach, not handcuffs and jail cells. We hope it will be a moment when the United States opens its arms to those seeking to join our neighborhoods and enrich our communities. And with that, I'm going to turn it over to Katarina Obser, who is going to speak a little bit about exactly how we can do that. Thank you.
Before Kat jumps in, I just realized I forgot to mention at the top that, of course, you can ask questions. Please do post them in the chat along the way, and there will be plenty of time at the end of the webinar where we'll be sort of collecting them as we go, and then we'll have an open question and answer period at the end. And so let me just ask Kat a question to start her off. As Heidi said, the United States, there are alternatives available. The US has tried them, although certainly not in any major way. Could you talk a little bit about those and how we could improve upon them?
Kat, I think you are muted.
Sorry, can people hear me now? I apologize. I'm dealing with working with two systems. So thank you for that. Thank you for the introduction, and thank you for having me alongside all of the really amazing panelists on in today's briefing. My name is Katarina Obser. I'm the Associate Director at the Migrant Rights and Justice Program at the Women's Refugee Commission. We are a research and advocacy organization that works to improve the lives and protect the rights of displaced women and children around the world. But before I answer Yael's question, and before I pick up where Heidi left off and talk about what we mean by alternatives to detention and why they're so important, I also just want to take a moment to center my remarks in the experience of the many dozens of women and men that I've spoken to over the years in the more than 20 ICE detention facilities that I have visited all around the country. Because as Heidi already said, and as you'll hear more directly in a moment, these are men and women who so often came to the US after an unspeakably arduous journey in search of safety, only to be met with a jail cell and a prison uniform. And the people I've talked to had families who they weren't allowed to have a contact visit with. They're individuals who have tried their hardest to navigate a system that sets them up to fail, largely in part because they can't get the help of an attorney because their prison is in the middle of nowhere, far away from most legal assistance, or because there just aren't enough lawyers to help. And person after person that I've spoken to has told me about just the indignity that they've suffered, the trauma of as Heidi described, this indefiniteness of the detention that they're in, and the unspeakable pain of not getting to hug their children. And for what? Why is this the approach that the United States takes towards people who are in immigration proceedings? Why does the US taxpayer pay hundreds of dollars a day so that thousands of people can be jailed simply for being immigrants or for having sought asylum in the United States? So I want to talk a little bit about what this system could look like instead and what's already been tried and how the US government can expand and improve on these prior attempts to support those who are in immigration proceedings using case management rather than prison. And the reason I'm going to focus so much specifically on case management, as you'll hear from others as well, is both because of what it offers, but also because of what it isn't. I want to start just by saying that often when you hear about alternatives to detention or ATDs, what the government, at least the US government, is often referring to is electronic monitoring. That can be telephonic check-in, but often it means a monitor strapped around one's ankle, limiting movement, tracking someone for 24 hours a day. This is a punitive approach, it's inappropriate, and it doesn't provide any of the support that most actually helps someone navigate an immigration case. But on the other hand, international research has borne out that an approach that respects human dignity and provides holistic, wraparound, comprehensive support and access to services is much more effective and appropriate. It creates trust in the immigration process, and as a result, it also creates greater compliance with that process and its outcome. So that brings me to a second point, which is that the government often frames the purpose of alternatives as being entirely around compliance. Compliance with court appearances, immigration appointments, and particularly under this administration, compliance with deportation. But that's a really narrow and totally inappropriate way of thinking about what makes for a successful alternative. Because an alternative should also be seen as successful not only if it promotes someone to fully and confidently participate in the immigration process, but also if that person can then find stability in their and their family's lives along the way. So there are many efforts around the country that try to help those who are in immigration proceedings with exactly these needs. But it's important to note that none of them are currently government funded, which of course limits how many people these programs can reach. And it also means the government doesn't see these kinds of efforts as an alternative to jailing people. It's also important to note that when the government has implemented what it calls ATD, again, often electronic monitoring, it's never been as a replacement of detention. It's always been in addition to the detention you've already been hearing about, which of course completely undermines what the whole purpose of an alternative should be. There have been some examples of when the US government did turn to case management and proved that it was an approach that could spare people being in jail, that for the government ensured compliance with the immigration process, and it also helped to create stability along the way. This began all the way back in 1997 when the then INS partnered with the Vera Institute of Justice and at significant cost savings to taxpayers, supported participants with their immigration requirements. More recently, from 2012 through 2015, ICE had a formal agreement in which it referred particular individuals in ICE custody to either Lutheran or Catholic organizations who would provide support and community-based case management services. And again, these resulted also in high court appearances. But most recently, there was a program called the Family Case Management Program, or the FCMP, and that was launched under the Obama administration at a time when, as many of you will recall, the number of families seeking asylum at the US border really began to increase around 2014. And so here's what you should know about FCMP, about what about it worked, what about it needs to change if and when the incoming administration considers a similar approach. So FCMP was directly rooted in the kinds of international best practices that we've talked about. The principle that was sort of at the heart of FCMP was that if you help a family in this program find stability, and again, I think that in and of itself should be seen as a measure of success, then you also promote compliance with immigration requirements and outcomes. FCMP was launched in January 2016, with families largely being enrolled either directly from the border or when they were released from family detention centers. It was a small program. It was in only 5 major metropolitan areas around the country. So it was in Miami, LA, Chicago, the DC, Baltimore area, and the New York and Newark area. It was a really unique program because it really emphasized individualized case management, with ratios of case managers to families that are much different and better than any other of ICE's ATD programs. When ICE ultimately evaluated the program internally, it looked not only at metrics like how many families complied with check-in appointments or court hearings, which by the way was a staggeringly high number of over 99% for each of those, But it also looked at how many families had been referred to services like for medical needs, for educational assistance with their children, or receiving a Know Your Rights presentation. And all of that cost around $38 per day per family, whereas the cost of jailing a family of 3 would cost something like $800 to $900 or more per day. This was an entirely new approach to how the U.S. could receive those seeking asylum in the U.S., and one that was intended to serve as a pilot. So there were less than 1,000 families enrolled in it overall by the time it ended, but it was intended to be expanded over time. But of course, that didn't happen because in June 2017, 6 months into the Trump administration, ICE ended the program. It cut off the families that were enrolled at the time for reasons that the report that I wrote on the program showed were entirely political reasons. And it wasn't long after, of course, that the Trump administration began separating families as its approach to those seeking asylum at the border. One of the things that WRC's report found is that a program like FCMP is scalable, both geographically, but also to others, not just families who may need support while they go through the immigration process. It's only political will by the administration and by Congress that stands in the way of restarting and expanding something like FCMP. But there's a couple of other key things that you need to know about FCMP, and the most important of these is that it was operated and contracted to by GeoCare, which is a subsidiary of the private for-profit prison company Geo Group. And so the way that it operated was that GeoCare subcontracted some of its case management to nonprofits in each of these 5 metro areas, but would handle some of the cases through its own in-house case managers while referring others out to the subcontracting community-based organizations. And WRC, of course, found serious concerns in the lack of GeoCare's depth of immigration, refugee, and case management experience. There was a lack of community ties and a lack of sort of experience in immigration management. And that meant that contracting with GeoCare reduced the ability to implement this program consistent with what we know are best practices around case management, ATD. So I'll just end by noting that case management is absolutely what the US should turn to, as it hopefully, as Yael said, fundamentally reimagines its approach to how to treat and welcome those seeking asylum at the border. It's not support that everyone needs, or that not everyone may need for the entirety of their case, but it is absolutely a model that the US government can and should invest in when it is grounded in the international best practices around case management and ATD, and ensuring that it doesn't repeat the mistakes of the past. And I'll leave it there. Thank you so much.
Thank you so much, Kat. And I mean, if there's one thing that has always been clear and seems to get a lot of attention, is how false it is that people released from detention abscond somehow in the community as a reason that we need to have detention. What we really do need is to release people and provide the case manager in the appropriate way and when necessary, just as Kat has emphasized. I'd like to just move on to the next speaker, Sylvester, and I'll give him a question to get us going, mostly a really general one this time, if you could just talk a little bit about your experience in detention, but also what you've been doing since then. Thanks. Sylvester, you're muted.
There you go. Can you hear me now? I just want to thank you guys for having me today. And as most of you know, I was in detention for like 9 years, 4 months. And my experience there was horrible. Like for the first 5 years, I had nobody like visiting me. There was no visitation. And I was just like in detention, no communication outside world until I met Freedom for Immigrants, Christine and them. Once they came into our lives, when I say our lives, I mean all detention detainees, we had hope, because before that, we had like constant abuses from detention officials, like verbal abuse, physical abuse, threats to segregation, like they force you guys to work for $1 a day. If you don't want to work, they take you to segregation. So when Christina then came to our lives, things started like moving. Like we could complain to them and they could like maybe call the jail's officials like, hey, why are you guys abusing them? What's happening over there? So that really changed a lot. So the last like 5.5 years of my detention went smooth, as in like they could gather for us evidence. If we needed like maybe contact lawyers, they could do that for us. So with them, we had a lot of hope. And since I've got out, I've started my own business, like Rafiki's Foods. And it's been a big challenge because when I was in there, they refused to release me. They said like, okay, I'm gonna go your friend commit. But my thing was like, I'm not gonna go your friend because I'm not drinking no more, you know. So when I got out, I kept my I'm gonna show them that by them releasing us, we not only would be a burden to the community, we're just gonna like do good. So I started my own business in 2016, Rafiki's Foods, which is doing really good. Before I got out, like it took immigration like 9 years, 4 months before for them to give me a bond, and I didn't have the bond with me. And Christina them they helped raise my bond for me. So that's another thing that really helped us on, like the bond us out, because sometimes we have people like just languishing detention, no bond, you know. The bonds are set high like 50,000, 7,000. I was lucky enough after 9 years, 4 months to get a bond for 1,500, and it was raised by Freedom for Immigrants within like 10 minutes, and that really helped me out bond out. Otherwise, I could still be languishing detention. Now, another problem is like after we got bonded out, having no work permit is like really difficult for us because it's like putting it out there with nothing, you know. Like let's say we are head of a family. Like if I can't work, how am I gonna support my family, you know? So that's another thing like needs to be looked on. When you get released there without a work permit, it's very difficult. It makes it so difficult for like us like to go out there and be good. It's like a catch, like a trap. You're really out there with nothing, and then we have to find work. We cannot work without a work permit. So I think we should maybe try to see how we can help us get those work permits, or what can be done when we get released, so we don't just go out there be a burden to the community. Now, my 9 years and 4 months cost taxpayers, like I was calculating 150,000, which that's a lot of money. Just me alone, 150,000. If I could have been released on bond like maybe 2 years ago, or 2 years into my detention, or the 1.5 years into my detention as I asked for bond, it could have saved taxpayers a lot of money. Imagine how many people like have been kept for a long time. Like money's the taxpayer money is increasing and increasing. So that also should be looked at, and there should be like Haiti said, alternative detentions. I mean, me, since I was there and what I know from other detainees is like, even if the ankle monitor is given to us, I mean, that's a huge relief for us, you know, instead of being in detention. But nobody should have that. You should just get released, like on supervised release, like maybe you sign a contract to whoever's going to receive you, that you're going to show up in court, and not like having to have ankle monitor, you know. That's kind of like still being in detention. And like I've done some research, and study shows that like 80% of the guys that are released on bond or supervised release, they show back to court. They attend the court appearances. So it's normally one thing the government always says that, oh, when we release them, they're not going to show up for court appearances, but that's not true. I've been out almost 3 years on bond. I'm still going back and forth to court. I haven't missed a court date, you know? So that's something like should be brought to the attention. Like we should figure out how we can maybe challenge this. Like that's one thing they normally use, like denying release, or they're not going to show up, which is not true. Another thing is like there's been a lot of deaths. When I was there, I seen a lot of deaths like due to medical neglect, you know, and those ones should be like brought up and raised, you know, because ICE and let's say Core Civic, who's housing us, they fight back and forth, because when you go to the Core Civic Medical and you, let's say you got a toothache or you something infection in your tooth, they recommend you to go to the outside medical. And if you show ICE that, and ICE is going to cost you like, it's going to cost them like almost 30,000, they don't want to take those medical costs. So what they do is they start harassing you, moving you to other facilities, or they immediately try to force you to sign to leave your country because they don't want to incur those costs. And so many times people fighting their cases and they have to go to medical, I've seen them like die. Like one of my friends died because he had simple toothache and it became to a large infection. So I've seen those ones happen, a lot of deaths in detention, and super sad, you know. Sometimes I cried myself, like, why am I being locked in a cage? What's happening to me? Like, why am I being treated like this, you know? So those are some of the things like has forced me since I've been out to continue fighting for my brothers and sisters who are there. I'm always willing to go. Like if I can go like protest, I'm always there, you know, because I want to give them hope. And by them seeing me out here doing good after all these 9 years and 4 months, I think it brings hope to them. And that's why I'm always constantly fighting and I'm always involved in activism. Thank you.
Thank you so much. And it's so important to hear sort of what happened while you were there. And I just think many of the things that you raised, Sylvester, really point at the fact that the ways in which immigration detention, though it's technically civil, have taken on so many dimensions, as Heidi said earlier, for our criminal justice system. So this whole idea of having large bonds that people need to pay to get out of prison, immigration detention, I mean, again, within our criminal justice system, people fighting for criminal justice reform have gotten rid of ideas of cash bonds. I mean, we should not be requiring cash bonds of people who many have not committed crimes. I mean, you're not being detained. Immigration detention is not designed to punish people for having committed a crime. If people have committed a crime, they serve their time in the regular regular prisons and then are transferred to ICE detention. So this detention is not supposed to be punitive, although it is. And many of the things that Sylvester talks about are. And then the other thing is the work that Sylvester mentioned in prison. I mean, under our Constitution, if you haven't committed a crime, you are not allowed to be forced to work. And that's when we abolish slavery, we abolish that idea. That's our 13th Amendment. And the idea that immigrants who have not committed crimes are in detention, and technically it's said that it's not forced work, but as Sylvester said, if he didn't work, there was this threat of solitary confinement, and the idea that people are forced to work in detention is really, really problematic. We wouldn't accept it in any other system, and the idea that it's sort of going on and it's acceptable in the prison system is something, as Sylvester says, we need to continue to fight back against. I'm going to turn now to Christina from Freedom from Immigrants to talk a little bit more about the alternative programs that FFI has that pushes back precisely against what Sylvester and I were just talking about.
Thank you so much, Yael, and thank you, everyone. So honored to be on this panel with all of you, and especially with Sylvester. Thank you so much, Sylvester, for sharing about your experience and the work that you're doing to continue to fight to abolish this system. Freedom for Immigrants really tries to prioritize learning from and with leaders like Sylvester who have lived experience. Sylvester worked with us to file our very first multi-individual complaint about abuse at the Etowah County Detention Facility in Alabama, where he was detained when we first met him. He was also one of the first people that, as he mentioned, we bonded out of detention, which is just crazy that it only costs $1,500 to bond somebody out, yet he was detained for 9 years and 4 months. It's absurd. But I will say that I think to date, our bond program has been one of our most successful freedom initiatives. So before I jump into that, I just wanted to share a little bit more about Freedom for Immigrants. We are a national nonprofit working to abolish the U.S. immigration detention system, and we're doing this through a two-pronged approach. So first, we are monitoring human and civil rights abuses in immigration detention. We've built a network of 4,500 volunteers that is a consistent watchdog inside the system. We started by building the first visitation program in California. So as Sylvester spoke about, we connect community volunteers to visit people in immigration detention as a way to end their immediate isolation, but really also to monitor the system. We now have volunteers visiting people in 69 immigrant prisons in 30 states on a weekly basis. Obviously, during COVID, there is no social visitation. That has been eliminated due to the pandemic, but outside of the pandemic, we're operating on a weekly basis inside these prisons. We also run a national hotline that is currently in effect, thankfully, that allows people at all 200 plus facilities to call us really at no cost to them. And it's really through these windows into the system that we're exposing how our tax dollars are being used to perpetrate abuse. Second, we believe that in order to end this system, it's not going to be enough just to uplift the problems. It should be, but we don't believe it will be. We have to, we believe, envision and to the extent possible, really model what a country and a world without immigration detention will look like. And we're doing this through our community-based alternatives to detention programming. So what does this type of programming look like for us? Well, it's looked very different under each administration. So for example, under the Obama administration, we focused on connecting asylum seekers who had passed their credible fear interview but didn't have a place to live in the United States to sponsors. So essentially community volunteers who had an extra room in their home so we could secure their release. But because asylum access and asylum parole have been largely under attack during the Trump administration, we really switched gears in the last 4 years to focus on bonding people out of detention as we did with Sylvester. We've raised over 2.3 million, all going back to the government to bond out 350 people. Of course, when folks finish their immigration case, that bond money is returned to us and we're able to recycle it to bond out more people from immigration detention. But we are really at a critical moment. You know, the current moment, I think, really represents an opportunity for this next administration, the Biden-Harris administration, and really for Congress and for all of us. Over the next year, I think we have the opportunity to both restore asylum access and to continue driving down detention levels. So as folks were talking about, immigration detention has been expanding since the early 80s, but due to the pandemic, ICE currently detains approximately 17,000 people in detention each day. Again, earlier in the Trump administration, it was as high as 55,000 people in immigration detention in the United States on any given day. At 17,000 right now, just for context, you know, current detention levels really are at their lowest point since 2006. A key component, I think, to achieving these goals will be really to invest in community-based alternatives to detention. So in order for us to continue to decrease the number of people in immigration detention and ultimately abolish it, we believe that we need to invest in community-based alternatives to detention. And we've already made some progress there. So for example, Freedom for Immigrants and the Immigrant Legal Resource Center passed the first statewide bill package in the country to put a moratorium on immigration detention expansion. So this bill package, called the Dignity Not Detention Act, was passed in California, which is a state that used to detain a quarter of all people in immigration detention in the United States. We then elevated the successful work to Congress, first through a House budget amendment that was introduced by Representative Jayapal in 2017, and then through a bill called the DONE Act, which was first introduced in 2018 in both the House and the Senate by Representative Jayapal and actually by Kamala Harris. So now the DONE Act, you know, if it had passed or if it passes in the future, it would have put a moratorium on detention expansion across the country. It also would have cut the detention population in half and actually used the money currently slated for detention to fund community-based alternatives. And so over the next few years, we're really gearing up for a push for a federal detention moratorium on expansion and for funding for true community-based alternatives at both the federal level and at various state levels as well. So, you know, what would a community-based alternative to detention program look like? One that's actually funded by the government. Well, I think you've heard from the other panelists throughout this morning or this afternoon, depending on where you're based, there really is no one-size-fits-all model of support. And in fact, international best practices developed by the International Detention Coalition also emphasize that there is no one-size-fits-all model, because the needs of a family seeking asylum with limited social ties in the United States are very different from the needs of somebody who has lived here for decades and built a life here. So with Freedom for Immigrants community-based program, we really work to secure the release of people from detention, or even sometimes before they are detained in adult detention facilities. We provide people with transportation, with a warm meal, with short-term housing, and we do this often through our network of volunteers. We also run a safe house in rural Louisiana for folks being released from many of the detention facilities in that state, which has seen a rapid increase in detention capacity under the Trump administration. Sometimes we're also able to provide people with long-term housing, and our staff has really been working to communicate with folks on a regular basis, ensuring that they know when their court hearings are, that they have transportation to their court hearings. We also try to connect folks to attorneys and local resources. But for us, and I think Kat spoke to this a bit too, proving that community-based alternatives work really has less to do with how many people actually show up to their court hearings, and really has to do more with developing a cohesive picture of what a successful alternative to detention program entails. So with our program, we're really illustrating the systemic roadblocks that prevent compliance with immigration obligations, as well as what makes individuals thrive post-release. So that said, nearly 100% of the folks who have been enrolled in our post-release community-based alternative to detention program have appeared for all of their required hearings. But in participant interviews, we are really kind of getting early indications that the simplest and least costly elements of our program, such as connections to one another and connections to community, are the most valuable from the participant's point of view. And I think Sylvester indicated that as well. And what we found is that there's really 4 main systemic roadblocks that must be addressed, I think, by our government and by any community-based alternative to detention program. And I'll just briefly speak about each of them. The first one is lack of adequate mental health care post-release. So we conducted a study that showed that 80% of people being released from detention have never seen a therapist, and 70% of the ones who have seen a therapist have not seen the therapist regularly. So to respond to this need and begin to show what a game changer mental health care can be for people who've been abused by our government, we've launched a pilot mental health program to provide therapy first for parents released from detention with young children. The second systemic issue is lack of legal means to become self-sufficient. So, i.e. no work authorization, which Sylvester also spoke about. The third is, of course, we all know, lack of connections to attorneys. 84% of people in immigration detention do not have attorneys, while the percentage of people, once they're released from detention, goes up in terms of how many people have attorneys. It's still not enough. And fourth, especially for recent asylum seekers, lack of access to housing. So I think we're making a lot of headway to address some of these systemic issues through innovative programming, but we really need the government to get on board. And I'd like to just end on a positive note, because I think I've shared some negative things as well as some, hopefully some hopeful things about the progress that we're making on community-based alternatives. But I do want to end just on a personal positive note. My great-grandfather came to the United States through a
Can folks hear me again? Yeah, okay. I don't know what happened. My phone died. But just to end on that positive note, my grandfather came to the United States through this bill that I mentioned called the Azorean Refugee Act. And then my grandparents and my father were able to follow. And our refugee resettlement system really provided an initial support system for my family. But we survived and we thrived really because of community. And there's no reason someone who walks across the border should be treated any differently than my family. And I think we're all here today because we fundamentally believe and we really want to fight for a country and a world where no person is imprisoned for crossing the border. So thank you so much all for being here.
Thank you so much, Christina, for that powerful message at the end, especially. And I mean, one of the reasons that I asked some of our Canadian counterparts to be on this at this part of this webinar is precisely because some of those services that you just discussed are things, and the way of receiving people at the border in Canada is a little bit different, and the government provides a little bit more support than our government does. So let's hear a little bit about some of the ways exactly maybe a government support could augment the kind of work that NGOs like yours are doing to help asylum seekers once they're settling in. So I'll start with a question for Jenny, and I think another reason I sort of asked the Canadians on is because when President Trump came to office, many here in the United States heard about asylum seekers or people in the United States who didn't have secure status heading north to Canada to ask for asylum. And then recently, the Canadian High Court found that the detention system in the United States actually made it an unsafe country for asylum seekers. Both of those things indicate that there's distinctions between the Canadian and US systems. How would you kind of compare and contrast the two systems?
Thank you so much for having me here today. So I'm going to try my best. I don't know the US system very well, and I'm really excited to be learning from all of you today. But I think some of what I'll share about Canada will hopefully help you to see the differences. So I work with a small NGO in the Montreal area. We support people who are detained in a local immigration holding center. Can you hear me well? Yeah, okay. So that's what we call the official detention centers here. It's run by the Canada Border Services Agency, which is sort of the enforcement branch of immigration. I visit this center myself on a weekly basis and have for over 15 years. In COVID, we've mostly been providing support over the phone, however. My main experience is in supporting detained asylum seekers, mostly detained for identity reasons. And in the past couple of years, most of those have come through Roxham Road, which I'm going to talk a little bit about later. Our immigration law allows for detention of non-citizens on several grounds, but by far the main reason is what we call flight risk, or someone's unlikely to appear. This is over 85% of detentions. One major difference you'll note is in numbers. So in the last reported fiscal year, there were 8,825 people detained for immigration reasons in Canada. So that's quite a bit lower than the States, though it is an increase from previous years here. The main purpose of immigration in Canada seems to be for removal. So refugee claimants at the start of the process are not typically seen as a flight risk and are not generally detained unless other factors are present. We don't have official statistics about how many are detained, but I would estimate a very low percentage. However, there have been exceptions. In 2009, 2010, we had 2 boats arriving in Canada with over 500 Tamil asylum seekers who were systematically detained, mainly on identity grounds, and kept in detention for months, even after providing identity documents. Boat arrivals have typically been very destabilizing in the Canadian context. So though the numbers of people detained may seem low, for those of us who work supporting people in detention, the suffering can still be significant. Many of those we met throughout 2019 and into 2020 had come north through the Americas. Many had experienced violence along the way, and some arrived with significant trauma only to find themselves detained. I can just think of a few examples: a parent and child who lost 3 members of their immediate family in a boat accident crossing into Panama, a mother detained with her children who had been sexually assaulted in the jungle in Panama, a father who'd been kidnapped in Mexico and then was separated from his family when they were released from detention ahead of him and he stayed locked up. I'm going to come back to detention a bit later, but I wanted to share the bigger picture of Roxham Road, a road that leads from upstate New York into Quebec, separated by just a small ditch. So we started to hear a lot about Roxham Road in 2017 when increasing numbers of people came this way on foot. In prior years, other people had come seeking asylum through other parts of the border. The main reason for coming irregularly into Canada would be the Safe Third Country Agreement, which was implemented in 2004 and which prevents most people from making a refugee claim at an official port of entry at the US-Canada land border. In 2017, Roxham Road became more widely known as a place where people could cross the border in relative safety and quickly begin their refugee claim. So though the past few years have seen a significant increase in the number of people entering this way, the claims by people crossing at Roxham Road are still only a portion of the total refugee claims in Canada. In 2019, Canada reports 64,045 asylum claims, of which over 58,000 were referred for a formal refugee hearing. During this period, about 16,500 people were intercepted between ports of entry, so came irregularly across the border. Everybody else came through other means. When people approach the Roxham Road entrance to Canada, they're told by the RCMP, which is the federal police, to go to the nearby border post, even though most would be found ineligible under Safe Third and actually turned back to the US. Those who do cross the border seeking refugee status are first intercepted by the RCMP and examined for possible criminal infractions, but are then taken to the border post for examination by border authorities. So one major difference is that most claims are found eligible, people are referred for an eventual refugee hearing and are then sent on their way. Claimants are given an identity document that gives them access to health coverage and, depending on the province, access to legal or social services. Some claimants are found ineligible to claim and are referred for removal proceedings, although they would have a risk assessment prior to their deportation. Unfortunately, that is far inferior to the claim process. So unfortunately, since March 21st of this year, the border was closed to refugee claimants due to COVID-19, and the Canadian government announced a reciprocal arrangement with the US to send people who had crossed irregularly back into the US, though they said that they had received assurances from the US authorities that these people would not be subject to enforcement actions. I can't confirm what happened to these people. Since April, 167 people only were intercepted in this way, and so a major drop in numbers. Since April, some claimants are allowed in at the border if they meet the Safe Third Country exceptions, and that's subject to quarantine rules, but everybody else is turned back. So you may see that there's a fairly rosy picture in terms of the welcome of refugee claimants. It's true that Canada has a relatively open view towards refugee claimants living in the community and does offer many services. However, this has been accompanied by measures intended to keep claimants out to the greatest extent possible. So the Safe Third Country Agreement is a key example. And indeed, when the federal court recently struck down the agreement, the government appealed and won a stay of the judgment while the appeal is being heard. Further, in 2019, in reaction to the rising number of claimants crossing irregularly from the US, the Canadian government made a legislative change that found anyone who was confirmed to have claimed in the US or 3 other countries was now ineligible to make a refugee claim in Canada. So they're referred immediately to removal proceedings, though they're eligible for this far inferior risk assessment, and they have more restricted access to some services. Canada also has a very wide array of interdiction measures, including visa restrictions, penalties for transport carriers, migration integrity officers in airports overseas, and generally making it very hard to come to Canada in search of asylum. I just want to go quickly back to the topic of detention. Since though numbers are low, the reality is that some claimants are detained and the punitive effect is disproportionately high. The government has in recent years expressed a will to make the detention system more humane. This has resulted in some specific policy changes of interest. A commitment was made to keep children and families out of detention to the greatest extent possible, resulting in a directive for officers in late 2017 to seek alternatives, preserve family unity, and give primary consideration to the best interests of the child. Unfortunately, due to internal inconsistencies and because this directive does not have force of law, the number of children in detention actually increased from 2018 to 2019. The majority who were in detention were not technically detained, but accompanied their detained parents who were usually there for identity reasons. From my personal experience, many of these families came through Roxham Road. So we've also seen a spike in family separations where one parent was detained while the other was sent to a shelter with their children. This has created significant suffering for these families. It's rare, unlike in the US, where you had some horror stories, it's rare that children would be separated completely from their parents, though we have seen this in some removal cases. So a final change has been to expand alternatives to detention. Prior to 2018, the only government-sponsored community case management program for release from detention was in Toronto. This was expanded nationally in 2018. Unfortunately, it has typically not been used for refugee claimants, and it's seen as not suitable for identity cases where authorities feel like they can't even evaluate the risk because they say they don't know who the person is. This actually undermines the policy directive intended to keep families out of detention. The directive calls for alternatives, but practically speaking, no alternatives are considered suitable. So just to close, one positive difference is that we do have regular scheduled detention reviews by an independent tribunal. This is imposed by law. And a recent update to the detention guideline used by decision makers has many improvements, although there is still work to be done. One of the impacts of COVID on immigration detention was to give greater weight to detention conditions, to view detention as increasingly disproportionate given the circumstances, and to favor alternatives and release. We now have very low numbers in immigration detention. It remains to be seen what will happen after the pandemic, and I do hope that some of the lessons from COVID may help to reframe the thinking around detention. So thank you very much.
Thank you so much, Jenny. Next, we'll turn to Francisco. And the question I had for Francisco was, most asylum seekers or refugee claimants in Canada are not detained, as Jenny explained. Can you discuss how they and their families settle into communities while pursuing their cases and the kind of resources that are available to them?
Thank you for the invitation. Yes, I will talk about the positive aspects and the regional differences. Because in Toronto, for different reasons, I am a refugee from El Salvador, and I am a survivor of detention or torture in El Salvador. And when I came to Canada, and my first job was with the detention people, the people that were detained here is something that was called the Celebrity Inn. That was 30 years ago. That was half of a hotel that was accommodated to detain people. And the technical issue was that was not a detention center, was a holding immigration center. And we started discussing all of these discussions, and I started using my example. I said, look, I have been detained, I have been missing in El Salvador, I have been tortured, and then a person coming here to make a refugee application, you put it in detention or you re-traumatize everything that you have. And that's something that I still using very often in discussions with. And I said, people that have heard this for maybe 25 times, I just said, you just know where I come from and what is my position about detention. This is the most inhuman thing that you can do. So please don't do it for people that only violate an administrative law that is immigration. So in that case, we have been working in my office for many, many years, around 30 years with the detention, the people in detention. And we managed to have a very good relation with the Canadian Border Service Agency. And we have even an agreement that are not written where they release women and children to us or families to us instead of detaining them. There is not written on paper, but there is a trust relation, and we always say, yes, we have a space even though we don't have it, but the idea is to avoid the detention. That's totally different in other regions of Canada, than there is not this community involvement. We even have an office inside the detention center here in Toronto where we go regularly and we talk to the detainees and we offer services and link to lawyers and access to legal aid and many things. So the situation in Ontario have been a little bit better than in other places. We are proud to report that the detention of children have been zero for the last more or less 10 months, and because the involvement of the community. But when we manage to, that a refugee or asylum seeker, that are very few detained, are released, is when we have to offer services. And the officers that we serve are, first of all, we link them to social assistance. So they receive a monthly installment for them to pay rent and to survive. Then we also link it to legal support, legal aid, and then when the legal aid is approved in Ontario, we link it to a lawyer. And we have many lawyers that accept legal aid and work specifically in refugee cases in Ontario. That is not the same reality that we have in other parts of Canada. Then we find then a place to stay. You know what I mean? In the meantime, either in a shelter, we have a specific shelters for refugee claimants in Ontario, particularly in Toronto, or in another shelter for homeless, or for domestic violence cases that are created for other reasons, but we use it when it's a women, then it's a women and children that are related to that. So all of that all of that issues are basically solved almost immediately upon the person appear in our office, or we are in contact after the person is released. Then they have access to English classes. They have access to shelter, as I said. The children are allowed to attend school until high school. When they graduate from high school, there is a serious problem to access post-secondary education. All the refugee claimants are basically entitled to receive an interim federal health program that give access to them to the Medicare, to the hospital, to doctors, to many things that are very similar to the coverage that we have in our universal medical coverage, the public health coverage that we have. And people can apply for work permit, and also when they receive the work permit, they apply for the social insurance number, and they are able to work. So this is everything that we do, and we have to do it very fast because the person has to be settled in Canada as soon, or integrated in a way in the different levels as soon as possible. So what we have now is that the whole situation of COVID-19 have changed all these procedures. First of all, because they are not really detaining refugee claimants, or at least the information that we have, is the majority of the immigration detention centers are detaining few people. For instance, the information that I have that in Quebec, in Laval, there is a accommodation for 109 detainees, and they have only 12. In Toronto, there is a capacity for 183. They have only 15, the last number that I received yesterday. And in British Columbia, in Surrey, they have the capacity for 70, and they help only 10. So that you can see that the COVID-19 have put a lot of pressure in the detention. But why? It's because it's similar to United States. If you are in detention, you are a liability to the system. So meaning that the Canadian Border Services, that is the institution in charge of all the detainees, they have to pay for medical attention. And in order, and that could be very expensive for them. And if they release the person and the person access the interim federal health program, is another institution than cover, that is Immigration Canada, than cover everything that the person will be. And it's way, way cheaper for the federal government to release the person to the society, to a shelter, to apply for Ontario Works or welfare, to attend a school, to work, than to keep it then in detention. And that has been one of the arguments that we have been using. So our main goal is that, as Jenny said, that this COVID-19 situation is going to give more examples about how um, is nasty is the detention of immigrants, and no reasons at all to detain. Than internal flight, it is not or doesn't need to be the main issue for detaining someone, because the person come to Canada to stay, not to flee. And we have been saying that, and the community have support them, they are going to stay. It's the welcoming of the person that decide how the person is feel when they arrive, and that's our role, to make them feel welcome. Then they don't have to go, they come back, and to give them a chance to make applications for permanent resident or to win their case as a convention refugee or protected person, in order that this immigration situation regularize. So that's what we do. I just want to end my presentation with two things. One is that one of the key persons of our committee that goes to visit people in detention here in Toronto had the experience of the Corralón in United States a long time ago. Eusebio was detained on his way to Canada. And he was detained for almost a year until the all sponsorship from the family here managed to kick in. And at that time, he was released and allowed to come to Canada, and he has been here for at least 30 years now, and is one of the most important persons in our role detaining. And he shared that information, the experience that he has in United States and in Canada with the people that are detained, to give them hope about how they could be released. And the second thing is that we have many cases of refugee claimants that they have been in detention in United States. Then they come to Canada after they are released, and they are accepted here. Some of them, we have the last case is someone that it is in detention in the United States and is from Cameroon. And that appeared in the newspapers here in Toronto, maybe 2 weeks ago, where he managed to make a claim over the phone with the Canadian border in Buffalo and Fort Erie. So, and they provide that person with an appointment to go and to present themselves. And the people that in Canada that are helping him try to convince the authorities in United States that he just come to the border, is going to make a claim, and they are going to be let come in, and and no problem. But the authorities in United States didn't approve the release of that person, and the person missed the appointment. And the problem is that that is taken as that the person make an application for refugee status. And even if the person is released later on in United States, that person may not be able to come and make a claim directly, and he will receive the second level protection that Jenny was mentioned, and is the pre-removal risk assessment. So we are dealing with detention in United States every single week. People that are detained but then come to Canada, people that are still in detention, families that are here looking for someone that is detained somewhere in United States and they don't know where they are. So our relation with detention in United States is so close, not because we want to, it's because the people here, are making us to become more and more involved and understand basically what happened in United States. And that's something that for us is very important to know, because has an impact, as Jenny said, in many cases in Canada. Because many of the people that arrive, I don't want to say many, but a lot of people uh, are having experience in detention in United States. And one of the first things that we have to do is to clear the air. Was an immigration detention, or was, the immigration detention was kicked in because was something criminal that you were accused, like the case that I have this morning. Someone that was accepted as a convention refugee, that was in United States for 9 years, then arrived in United States when he was 14 years old, and was, he said, voluntarily let go back to Mexico when he was 21, after he was detained by police due to different things that he didn't explain to me. But he said, but I am pretty sure that I don't have any charges and I was released and whatever. So we said, we gotta check it. Can we talk to a lawyer in United States or someone to give us the papers in order that we know how to present this case here? That happened almost every week, because the main entrance to Canada for migrants and refugees and asylum seekers is United States. We have almost 4,000 kilometers of borders that communicate us in a way that is not possible even to describe. So that's our experience with them, of detention in United States and in Canada. Thank you.
Thank you very much, Francisco. The Cara loan that Francisco was mentioning is now, it's sort of where our Port Isabel Detention Center is in Texas, just for those of you.
Yes.
That's been a problem for a long time, still a problem today. We have a lot of questions from the audience and not that much time, so I'm going to quickly take the first one myself and then pass on the next couple to some of our other speakers. The first one has to do with, the question is, do we have a reason to believe that the Biden administration will reform some of the policies that we've been talking about, and what would differentiate new policies in the next administration from what's been happening? So President Elect Biden has said that he would end for-profit detention centers and ensure that asylum seekers are detained with dignity. That's part of his program. Want to make sure that happens. I mean, a good thing that he could do on day one would be to sort of announce an intent to actually terminate those contracts with private prison companies, and then just make the system, as much as he can administratively, assume a presumption of release rather than detention, because that's basically where we are now. So there could be custody determinations for asylum seekers and presumption of release. We could eliminate some of the cash bond issues that we've been talking about earlier and move towards a case management system. I mean, there are ways in which you expand what mandatory detention means even under our law to include some of the alternatives that are available. So even if people have to be mandatory release, maybe they can be released into one of the alternative programs and not actually be kept in detention. You could end family detention quickly. And then there's the standards in existing detention facilities, you know, the ending the use of certain practices like solitary confinement, ensuring access to counsel, medical care, food. And then there's stuff that Congress can do. The president can only do so much on his own. One thing is we're up against appropriations. Appropriators in Congress could stop giving more money to enforcement and start allocating it actually to alternative detention programs that we've been discussing. And I just want to say, you know, when the border crisis happened in the spring of 2019, the administration could have called it an emergency, and rather than pour all this money and defense money into the wall, which is basically where the money went to building a wall, could have actually declared an emergency like it would under a natural disaster called for FEMA, and actually allocated money to different states who then could have given money to nonprofits to actually support asylum seekers, who basically the administration was just dumping into cities, bus stations all over the country and not providing any funds. In fact, to this day, Pima County in Arizona, which shelled out money to provide shelter in one of its shelters for those asylum seekers that they asked the federal government, can we use some of the money that you've already granted us for enforcement through Operation Stone Garden, which is this big enforcement grant that Arizona gets? Can we use some of that for humanitarian aid for our shelter? And DHS said, no, you cannot. And that is what we're up against, sort of saying that money can only be used for enforcement rather than putting the money from the federal government into more humanitarian programs. So that's what appropriators can do. That money can be appropriated in a way that is much less focused on detention and much more focused on more humanitarian programs and alternatives. And then there are some specific bills that have been introduced in the past. There's a bill that recently was introduced to end transfers between detention centers. There's an Immigration Enforcement Moratorium Act, which is these are COVID related, focused on COVID, that we can't have transfers between detention centers. We have to stop some immigration enforcement issues during COVID because it's a risk. And then more generally, the Dignity for Detained Immigrants Act, which was introduced in 2019, really mandates a lot of the things that I've been talking about, such as giving all detained immigrants access to a bond hearing, shifting the burden to the government to prove that they should remain detained rather than be released, and then ensuring conditions of detention are humane and requiring sort of more monitoring of those conditions. So those are some of the things that, we could do to improve things. Let me move on to questions to specific speakers. Kat, could you say in like a minute or two, a little bit more about the day-to-day workings of case management, so where families live, kids go to school, how they're treated and integrated into communities?
Sure. I mean, I think Christina said this really well, that this is not a one-size-fits-all situation, right? Everyone is going to have different needs. But I think the idea behind a case management approach is that there are, and this was, I think, particularly the case in the family case management program, is that you had folks who already had somewhere to go in the community. They had someone that they were going to go live with in the, generally speaking, in the 5 metro areas where that program operated. But then they received that additional support in the form of a case manager, right? So the idea is you have someone who has a who ideally has like a social work or similar background, right? This is not as much of a law enforcement approach, who then helps that person make sure they understand what's happening in their immigration process. Who, if that person has children who need to be enrolled in the local schools, understands what the requirements of the local schools are for their kids to be enrolled there, and helps them out with making sure that that can happen, right? What forms need to be filled out? Do they need vaccinations? Does that person need access to support like, you know, to mental or medical health care, and how, you know, can that case manager make a referral that would be appropriate for the person enrolled in the program? So the idea, I think, there was that largely there were, you know, there was already someone in that community who the person enrolled in FCMP could live with or stay with, but then they would have this additional support provided them through a case manager. And of course, maybe most importantly, I think all of it's important, but one really critical piece is that the case manager can also help facilitate connections to legal services groups, right? So that that person can have that understanding of the legal process and ideally be connected with an immigration attorney to support them throughout their case. One thing that I think is really important and that we saw when looking at FCMP, and that others have talked about as well, is that I think any future iteration of something like a family case management program also needs to see housing as a really central element, because there are, of course, people who will arrive, particularly at the southern border. Many people do have somewhere to go already in the United States. They have family or friends who they can, you know, safely go live with. But there are some people who may need short-term or interim housing while they settle into their community. And so that's something that I think would be important in a future case management to be looked at, to ensure that housing can be a component that's, you know, but appropriate, right? Like housing for someone in that situation.
Thanks, Kat. Heidi, this question is for you, and it's about how we sort of wiggle out from under the inhumane system, given the huge profit motive for groups like GEO and Core Civic. So how do we sort of get away from this?
Yeah, thanks. And I mean, you know, I'm going to give the bite-sized version of that since we only have a minute or two. But I think that the short answer is you'll hear the term phase out a lot, right? And that's because advocacy groups have been working for a long time to get ready for this moment when there are clear steps that can be taken, even without legislative action, to move towards a full phase out of this system. Government actors should not be beholden to the private prison industry, right? And we were almost at a moment at the end of the Obama administration when there was going to be a phase out entirely of the use of private prison companies to run and operate private prison, to operate federal prisons. And so let's start there, and then let's shut down the worst of the worst facilities that Freedom for Immigrants and others, Women's Refugee Commission, have identified. And then let's close down all the county jails. Let's adopt the presumption of detention. Let's take a really hard look at the front end, right? So what are ICE's policies about who they actually arrest? Who has to be put into the system to begin with? And on the border, obviously, let's move away from the use of expedited removal and adopt the myriad case management programs that we've discussed today. And it's not too long before you get to a moment when detention has been rendered obsolete.
Thanks so much. We just have one more question, and I think this is towards Christina, which is that it's not so much that aren't unique models, but how do we sort of scale them up, and where the burden is ultimately placed for sort of supporting the programs is on the community. So how do we basically guarantee success in different local communities to make this really work on a large scale?
Yeah, it's a great question, and I think it's especially appropriate given that you all are the Refugee International, because we've really looked as an organization to the refugee model. So, you know, in this country, in the United States, in the 1970s, it was both basically ethnic groups, community groups that were modeling what our federal refugee resettlement program ultimately became. So I think what we see ourselves as is something similar. We're modeling what it could look like, but ultimately we need, we need federal dollars, and we know that it costs about $165 per person per day. Sylvester spoke to that, to detain an individual. Our program right now, it costs $15 per person per day. Most programs around community-based alternatives are at that low amount. So we don't need even the money that's currently slated for detention to fund community-based alternatives, but we do need a public partnership. But I think we don't necessarily need to scale it on our own. We just need to, show that this is possible, and we need political action on the part of this next administration and the part of Congress to say we no longer want to be a country and a model for the world for imprisonment of immigrants.
Thanks so much to all of our panelists. This was tremendously interesting for me and a great learning experience, I hope, for everybody in the audience. We'll be following up with some kind of calls to action based on the conversation today and some explicit ideas about how to make these alternatives really work and ways you in the audience can help us push for these alternatives moving forward. Again, thanks to you all for coming.